Aman Lekhi, a well-known Supreme Court advocate. Former Additional Solicitor General Tanveer Ahmed Mir joins us, Zafar Islam from the BJP and Rohan Gupta from the Congress. I want to go to Aman Lekhi first. Mr. Lekhi, the fact that the court in Surat has convicted Rahul Gandhi in this case of defamation, when there are comments made by various leaders, many in the BJP, which prima facie seem defamatory as well, but in this case a conviction for defamation has been given, in other cases it wasn't, is leading opposition leaders to wonder whether this conviction would have happened if the case was outside Surat. Would any court outside Gujarat also, according to you, on the basis of the evidence that existed, have come up with such an order?
Well, firstly, I just happened to hear what Mr. Sundaram said. I still can't see you, Rahul, but I'm still speaking. I presume you are there.
I hear you.
What is very important here is, no one is talking about the relevant provision here is 199. Now, 199 is an exception to criminal law, because in criminal law anyone can initiate proceedings. However, under 199 is a requirement of a person aggrieved coming, and because the law requires, in a case like defamation, which has an overlap with speech, to limit it to cases where criminal prosecution is in fact warranted by a person being specifically aggrieved. And because person aggrieved is not defined, insofar as the meaning it is to be given depends upon the offence and the circumstances. Now, the offence and the circumstances in totality quite show that the target of Rahul Gandhi's barb, uncharitable as it was and lacking in finesse, was actually Mr. Modi. Now, Mr. Modi has not actually filed, and rightly so, has not filed a complaint. However, the complaint has been filed by another Modi, saying that he belongs to a group. Now, merely belonging to a group will not entitle a person to file it, because the group has to be ascertained and defined. And insofar as Modis are concerned, they not only cover OBCs, but they will cover others also. And in addition, the person who is going to the court must show how he has been injured by that particular comment. Now, whether this threshold requirement of 199 was satisfied, because in a political discourse, things are spoken, and they're spoken across the spectrum. You have this similar kind of profanities coming from all sides. Now, because you get coming from all sides, and this is the low level of political discourse in the country in any case, easy resort to defamation, so that courts become tools of a political slugfest has necessarily to be avoided. And there has to be some kind of maturity in the judge who's actually hearing the matter.
No, sure, you're making a larger point. I'm asking you a straight question. The fact that the judge says that 13 lakh people have been defamed, have you ever heard that earlier? Somebody saying that 13 lakh people have been defamed?
It is inappropriate. It is inappropriate that this is so. As far as the comments are concerned, the judge has to limit himself to the fact of the case and the law. And any comment extraneous to what the merit is unwarranted. And you are right, the law is also a question not only of the order but perception. And the very fact that this is actually in Gujarat may actually lead to this kind of view that it may have been motivated by something, but I don't join that. Mainly because the court is in a particular place doesn't necessarily mean that insofar as...
So you're essentially saying that you think that the order is wrong?
Yes, what I'm saying is the order is not correct, because the threshold requirements according to are not satisfied. This person could not be the person aggrieved. In any case, it is outside explanation 2 of 499. And in the circumstances of the case, in fact, because defamation is punishable with imprisonment or fine, he says this is repeat offence, because the repeat offence it aggravates. The point is, every politician is a repeat offender. And because every politician is a repeat offender, when the matter comes before the court, and this is basically an issue between politicians, I personally think the court should ideally, in a matter like this, particularly when it's a question of a statement being made in a political meeting, choose to be a bit more discreet in the use of law, which in any case has necessarily to be restrained because of its overlap with speech. I'm not defending what Rahul Gandhi said, but the point is the lack of caliber, want of erudition, and complete absence of finesse is not only in Rahul Gandhi, but is across, as I'm saying, the political...
Now, you make a very important point. I want to put that to Syed Zafar Islam. Aman Lekhi, given his background and his standing, coming out clearly and saying he thinks this order is wrong, and therefore for the Lok Sabha Secretariat to have disqualified Rahul Gandhi seems odd. And the fact that you've got a judge who says 13 lakh people have been offended and defamed, and the person against whom that comment is made, he's not gone to court. He seems to find several things wrong with the manner in which this case has been decided.
Just a minute, Rahul.
Rahul, first of all, the court has pronounced the judgment. It is not the Bharatiya Janata Party, or for that matter, the government, or for that matter, the Secretariat. It's the legal position. What is to be affected has been done by the Lok Sabha Secretariat. And they have just implemented what has been pronounced by the Honorable Court. They have the right to appeal, but as far as the observation made by the Honorable Judge is very, very clear that people have felt offended because of the statement he made.
But
and
you
it's
know,
not
you
only
also heard what Aman Lekhi said. Politicians make all kinds of comments all the time, which are very offensive. And you don't have, you just, because the politician saying it, and in the past as well, judges have held politicians to different standards, saying in the political heat, these kind of things are said. It's not taken literally.
Rahul, if anybody feels offended, he or she has the right to approach the court. If nobody has approached the court, you will never feel or get to know that whether the person has been offended by the statement made by any politician. In this case, there is somebody who felt offended. The entire community felt offended. They approached the court. But
this also doesn't happen. 13 lakh people don't feel offended at the same time.
You cannot question the Honorable Judge because he has more evidence than you have. We are simply discussing here and debating on the judgment he has pronounced. But he will have access to more information. He may have cross-checked many other information which you and I don't have access to, and may have spoken to people.
No, what I find odd, Rohan Gupta, is that you've got a battery of lawyers, Abhishek Singhvi, Chidambaram, many others. You could have gone to court this morning against the conviction of the Surat court. It seems the Congress wanted to allow this issue to simmer politically so that Rahul Gandhi becomes a political martyr, so your party can benefit in the next election. Otherwise, you would have gone to court. You actually want this to play out because it suits you.
Absolutely not, Rahul. I was.
Why didn't you go to court this morning? Why didn't you go to court this morning?
I will answer that. Let me just give my opening comments and then I'll answer that.
Sure.
The point number one, one of the lawyers said that the defamation part of it, when it is a criminal defamation, as rightly told by one of the person, the group needs to be defined, and the person who is going to the court, it has to be clearly identified that is the aggrieved person. Here, that is not the case. Mr. Rahul Gandhi has never taken name of Mr. Purnesh Modi. Number one. Number two, Rahul, I want to give more facts to you in this case, how this has happened. In 2019, the case was filed in Surat court. 2021, Rahul Gandhi comes and records the statement. Again, the applicant, Mr. Purnesh Modi, files again to call Mr. Rahul Gandhi in 2022, where the judge rejects the application to call Rahul Gandhi again. The same applicant, the complainant petitioner goes to the High Court and takes stay against his own matter in magistrate court, and the stay was given. After 1 year, in 2023 February, the same petitioner goes to High Court, gets the revocation part of it, goes to the magistrate court and gets the order. Have you ever seen this kind of process? No, we have not. We are not disrespecting the decision by the magistrate, but at the end of the day, the way the process has been followed, the way the things have come, it is about for the people to decide. Number one, there is a difference between political judgment or political wrongdoing and legal or judicial wrongdoing. What BJP spokesperson was talking about, it's a political, maybe it is his political opinion. But when you are following a judicial process, there are the laws, the rules to be followed, which according to us, I think it is not followed properly in this matter. And answering your question, the written order is required for filing the application or the revision, this thing. The order was passed yesterday. The written copy is available today morning. So obviously, by the time
Tanveer Ahmed Mir, I've heard two perspectives. Aman Lekhi saying this order seems to be incorrect because a whole community seems to have been offended. That's not how criminal defamation works. It has to be filed against the person who claims he's been defamed, and then that needs to be proven on the weight of evidence in a court of law, which doesn't seem to have happened in this case. Why do you come out on this, Tanveer?
Well, thank you, Rahul, for inviting me. Once Mr. Lekhi has spoken on this issue, I don't think anything else needs to be said to add to that. But I would like to tell you that, first of all, in a criminal defamation case, usually it's a one-witness case. So the complainant who comes to the court and files a private complaint, now as against a serious offense like, causing communal disharmony, which is 153A, 153B, any person who is an accused is prosecuted by the state, but criminal defamation is not considered to be a serious offense Therefore, the state doesn't prosecute anybody for criminal defamation. So it is to be prosecuted by the complainant in his personal capacity. But there is one important point, which I must say here. Since a lot of senior lawyers have talked, in Lily Thomas's case, the provision of subclause 8 and subclause 4, which gave, say, about a 3 months abeyance rule before the disqualification comes into play, was done away by Honorable Justice Nariman in the Lily Thomas case. And in 2013, when Congress was in power, the then dispensation and government came up with an ordinance to bypass Lily Thomas. And in a press conference, it was Mr. Rahul Gandhi himself who tore that ordinance and threw it away. That by no stretch of imagination should anybody, convicted in a criminal court have any kind of benefit. So it seems to me that time
that's the irony of it all, that this is largely a doing of the Congress. But I want to go back to Aman Lekhi on the issue of whether the next logical step is to appeal before a sessions court, or does it make more sense to appeal before the Supreme Court?
No, absolutely. They have to appeal for the session. That's the correct option. But you see, I just heard you mention the Lok Sabha's the Secretariat's notification. You see, what is very important here is technically Lok Sabha could have issued, because the disqualification goes back date of conviction, which has actually happened. I have a reservation of the speed with which it has happened, and I have my own view on this, because we have to look at the provision of the Constitution as 102 with 8. Now, the word used is conviction. That this is, however, as far as the conviction is concerned, by the court, the court of original jurisdiction, in this case, the JMFC's court. The point is, in law, there's a right to challenge, because when you've got an appeal, you've got a right to challenge. And as soon as you've got a right to challenge, implicit in the fact that the sentence has been suspended. I personally feel the Lok Sabha ought to have propriety demanded awaiting the outcome of the appeal.
No, but I want to cite something to you, and I want your thoughts on this. When Samajwadi Party leader Azam Khan was declared disqualified by the Speaker's office within 2 days of his conviction, the same UP Assembly Secretariat took a month to disqualify BJP MLA Vikram Saini. Lok Prahari Secretary S.N. Shukla, who is one of the petitioners in the 2013 Lily Thomas case, is quoted as saying, while opposition party members are disqualified by the Speaker's office immediately, they tend to delay the disqualification of members from the ruling dispensation. It almost seems like jiski lati uski bhains.
No, you see, law is not to make a distinction between the political parties or political persona. That's the birth of law. Now, that's exactly what I'm saying. What I'm saying is, as a matter of rule, when there's a conviction and there's a right to appeal, and in a case like this, more so when the sentence has been suspended, in that event, implicit in it is that then appeal is going to be filed. Before the 30-day window, which is in fact provided by order in this particular case, an order of disqualification will virtually frustrate the appeal, because that will negate the purpose of the stay. So the Supreme Court has said that will lead to the stay of the disqualification notice. However, the disqualification notice robs the appellate court of its jurisdiction, and therefore it is a case of interference with the judicial power. And because it's a case of interference with judicial power, for that reason it loses its legal content as also moral legitimacy. My view is that once there's a conviction, until there's an appeal, till there's an affirmation in the appellate court of the conviction, there should not be an easy resort to a disqualification notice, because that will be a reasonable interpretation about 102 read with 8. All they say is conviction. But when you waive the conviction, the legal process comes in, and the right to challenge to conviction has to be read into it. Now, when I have a right to challenge the conviction, and this is an order of the first court, until that order is affirmed, I do not think that there should ever be a situation where the Lok Sabha Secretariat should be hasty in bringing about a notification, because this is grossly improper. And in fact, that's the reason why because there's no imbroglio over here. It stares me in the face that as far as this is concerned, this is wrong, and it's a case of preempting a judicial outcome. And preempting a judicial outcome will not behove any coordinate organ of the government, and is technically contempt.
Okay.
Apart from the fact that it is an abuse of law.